Turning now to Florida for the trial dubbed the Thrill Kill Murder Trial. This is the case in which the defendant, Justyn Pennell, is scheduled to be sentenced tomorrow after he actually pled no contest yesterday, avoiding a trial that we expected to begin this week. Prosecutors claim that on January 9th of 2020, this 21-year-old Pennell ran down and killed a 75-year-old pedestrian. He did so with his car. According to an arrest report, Pennell told authorities he wanted to know what it was like to kill someone. During a press conference, the Pasco County Sheriff said that Pennell drove his Chrysler PT Cruiser past the older man. Then he actually pulled a U-turn and aimed for the man, killing him on the scene. Court TV legal correspondent Julia Janae is here with me with more background on this case. Julia, start please if you would. Do you know why he entered the no contest plea instead of going to trial this week?
Well, we're getting some insight into why his team and why this defendant told the judge that they would not be wanting a trial even though the jurors were in the courthouse, potential jurors waiting to go through voir dire. But it had to do, we believe, with some of the rulings that the judge made not too long before this trial was supposed to start. There were actually two motions in limine that were outstanding, and that ruling came from Judge Mary Hansel on Friday. And it seemed that that had an impact because it was going to have an impact on what this defense could put in front of this jury. In particular, the diagnosis that may have been given to this defendant by medical professionals. And it's something that the judge asked him specifically. So take a listen, let's first, to what he had to say when she asked him that question. He has a lot of pauses, but he eventually gets to exactly what his treatment has been.
Have you ever been diagnosed with a mental or emotional illness?
Yes, ma'am.
All right, and what was that?
Asperger's, depression, and PTSD.
Okay. Did they recommend that you take medication for that? Yes, I believe so. Yes, ma'am. Okay. But you're telling me that you're not taking any medication at the jail, correct?
No, ma'am.
No what?
I'm not taking medication at the jail, ma'am.
Okay, so you were diagnosed with a mental illness or defect, you were prescribed medication, and you are not taking it. Do I have that correct?
They recommended medication. I'm on medication.
Is it that because you are choosing not to take the medication? Is it your choice?
Yes, ma'am.
All right. Is there anything about the fact that you are not taking this medication that's having you have a hard time understanding what you're doing here today? You understand what you're doing here today?
Yes, ma'am.
What are you doing here today?
I'm pleading no contest to life.
Okay.
And I retain my right to appeal.
Okay. And you understand that the only sentence that I can give you is life, correct?
Yes, ma'am.
Really critical questioning there from the bench. She had to make sure that he understood what he was doing, even though you heard him there saying he's not taking that medication. But that diagnosis is important because the judge had ruled that it could not come in front of this jury. They weren't going to know about the Asperger's, the depression, the items that he just listed there, the PTSD that he said were relevant.
Fascinating to me that I thought, and we were just talking as I was watching it, and I said, oh, wow, he's not on his medications now. And you're right, that required that judge to really do a deep dive to make sure he understood, and it was knowingly, voluntarily, willingly entering that no contest. All right, now I understand, Julia, there were some statements that the defendant made to the detectives, rather, that the defense wanted to keep out.
Some pretty damning statements he made that suggested that this was not the only person that he wanted to kill and that he planned to kill more. Here's a look at some of the things that the defense put in their motion in limine, saying that they were irrelevant, they were unfairly prejudicial. One of them that he said to detectives, I'm really fond of knives. I was thinking about slicing people up and cutting them open, dissecting them, essentially. Another statement, I wasn't sure I could kill anyone. I could have stabbed several people, but I wasn't sure they would die, so I ran the victim in this case over. Now I know I can do it. We know the victim in this case, he aimed that vehicle at him and killed him. That was a stranger, but he also told these detectives he had a list of people who were bullying him that he wanted to kill.
And the fact that he says he thought of slicing them up and killing them, it begs the question a lot of people would ask and want to know. Julia, 21 years old at the time this happened. 3 years later, here we are, he's 24. Is there any chance that he is going to get out of jail after the sentencing hearing?
No chance from this sentencing. Florida doesn't have parole for first-degree murder, and the judge made it clear to him that I'm giving you life. That is what the penalty is for this first-degree murder charge. But if he appeals, which is likely the reason that he pleaded no contest, he still has that opportunity to file that direct appeal, arguing that the judge should not have denied his right to put in that diagnosis in front of the jury or to keep these really problematic statements out. He could get that sentence overturned and then a new trial.
All right, thank you always for all your legal expertise. Julia Janae here in the studio, appreciate everything you do. I want to bring in now our forensic psychologist, John Delatori in San Antonio, Texas. John, anybody watching this is going to say, what is wrong? Why would a 21-year-old purposely, intentionally do this?
Yeah, well, the first thing that I want to talk about is removing the idea that mental illness really had anything to do with this, whether it's the Asperger's or PTSD or major depression, whatever those things. We need to remove that from the conversation because mental illness in and of itself does not make someone more or less violent. In fact, it often makes someone more likely to be a victim. But there are key things that are going on here. Number one, we have this history with him running away from home. We have this idea that he wasn't able to get into the Army. Then we have this idea that he was being bullied and that some of these people that he was bullying were all on a list of individuals that he was going to kill. And he even targeted the actual victim in this case. He targeted, right, drove past him, then made the U-turn. All of these things seem to suggest someone who was isolated, alone, feeling frustrated and angry, upset that the world is preventing him from being a better person, so that he ultimately wants to get control back. He wants to get power back. And one of the ways that in his mind that he thinks that he can get control back, that he can, exert his power, is by playing God, right? By killing someone. And he fantasizes and fantasizes until the point that he feels comfortable actually doing it. And in this case, it was running someone over.
Knowing that he's made statements that indicates that, yes, he fantasizes about killing other people and how he's going to do it. In your expert opinion, is there anything that can be done to treat him, to ensure that he doesn't get out of jail and kill someone else?
I think so, but it depends on, is he willing to be compliant, number one, with medication? So now is where we bring mental illness back in. He needs to be on his medications because clearly there are things that are going on. It's, there's a lot of theories that suicidal ideation and homicidal ideation are just inverses of one another. And so it's certainly possible that on medications with the appropriate therapy to treat whatever the underlying condition is can certainly help him overcome all of these obstacles that he's faced in his life.
Well, it really begs the question. A lot of people that I talk to about mental health concerns, they feel like, well, if a person is incarcerated for some crime they've committed, to your point, absent the mental health issues, but that they have the opportunity then to have the medications given to the individual so that they're medication compliant. But the fact of the matter is, and this is my question for you, John, isn't it true that you can't force anyone, even if they're incarcerated, to take medication? That's their choice, and we just heard him say he is not on any medications.
No, you absolutely cannot force medications upon anyone. Under certain circumstances, you can, whether the person is a danger to themselves, danger to others, or pervasively or gravely disabled, but none of those things rely here. But what I'm going to say is that if there's a possibility for parole, which in this case it sounds like there isn't, but if there's an appeal in which parole could probably be added, it's certainly possible that that could be something that shows that he's willing to do what he needs to do to prove that he is a better citizen to live in society moving forward.
All right, Dr. John Delatori, thank you as always for joining us, all your great legal analysis, and really your expert as a forensic psychologist. Greatly appreciate you coming on today.